are entering and they are referring regularly to YouTube. Friends, our earlier programs and recording you can very well see and listen to it while you are free, and that is available on YouTube. That is Decoding Corporate Law with Mehta and Mehta. Welcome to all. So, welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. Today, as you know, we are starting webinar series on an insight into SEBI insider trading regulation. People, friends, there are earlier also webinars, but continuous amendment, continuous further study, and continuous further discussion on the topic is required, and it every time evolve as and when we discuss. So we are starting this series, and today is the first session. And today's we are discussing on definition and certain key terminology of insider trading regulations. Very important for this because that clears the meaning of the words. And today's our panelist is Ms. Hema Kumari. Ms. Hema Kumari is a fellow member of ICSI and law graduate from CCS University. She holds BCom degree from Ranchi University, has over 19 years of experience in compliance and secretarial matters of listed companies. Currently, she is working with Dan Networks Limited as CS and compliance officer. Prior to this, he was associated with JK Group as a company secretary and compliance officer of Udaipur Cement Work Limited, a listed subsidiary of JK Laxmi Cement Limited. He has also worked with India News Group and Rungta Irrigation Limited. Welcome, Ms. Hema. Thanks a lot for your time.
Thank you, ma'am. Thank you so for inviting me. It's an honor for me to be here. I have been participating as an audience, and now it's really honor to share this platform with Sudhakar sir, Dipti ma'am, Bala sir. Thank you.
Thank you. My pleasure. Today's our presenter is Ms. Sakshi Gupta. Sakshi Gupta is an associate member of ICSI and has completed her Bachelor in Commerce and Law. Previously, she has worked with MCX and has experience in the fields of incorporation of company LLP, increased capital, conducting board AGM, compliance of SEBI LODR, security contract regulation, and SEBI prevention of insider trading regulation, Companies Act, FEMA, etc. So today's our as usual, our another panelist is our Sudhakar own Sudhakar Saraswatullah and Mr. Bala, our moderator, as usual. Thanks everyone, and we thank all our panelists of today's webinars for joining us on our knowledge sharing journey on behalf of entire team of Mehta and Mehta. Welcome all. With this, I'll just say this today's topic. People will think that why the definition and terminology, but friends, unless and until each and every terms and definition is clear, you will not be able to understand whether you are governed by that provision or not. This definition decide whether you are governed by that provisions or not. And each time you will read definition, each time you will get a new, different meaning. So with this, I'll request our panelist, Ms. Hema, to say a few words on the topic. Then Mr. Sudhakar and Bala, and then Sakshi, you can start the presentation. Over to Ms. Hema.
Thank you, ma'am. Since the introduction of SEBI PIT regulation, SEBI has been continuously tweaking and fine-tuning this regulation. And now they are using the digital methods like audit trails, digital mapping, WhatsApp also to prove the charges of insider trading. And while the SEBI side has grown, but it has also posed practical challenges for all the stakeholders, especially for the compliance officer, professionals, as this PIT regulation is not only applicable to the listed entity, but it extends beyond that to the secretarial audit firms, auditors, merchant bankers, and many times it's not that this breach happens due to intended reasons, but many times it happens out of ignorance also. So it's always and since we professionals, especially the compliance officers, have to bear the burden of compliance and to create awareness, it's always important to know the practical means practical to have the practical knowledge of this terminologies, to have the know what is right and wrong, do's and don'ts. And with this, I am really thankful that Mehta and Mehta has organized this webinar on insider trading, which is an apt topic for all professionals today. And I'm looking forward to participating in discussions to share my insights on insider trading and be part of this discussion. Thank you, ma'am.
Thank you. So over to Sudhakar.
Yeah, good morning, everyone. In fact, you may recollect that about 3 years before we had the same series on insider trading regulations. We have extensively discussed this about 6 webinars or so. We thought that after 3 years, a lot of some changes have come, plus a lot of we could mature further as far as the insider trading regulations are concerned. So we thought that let us have a discussion again on this particular thing. So we initiated this particular masterclass on insider trading regulations. In fact, I am delighted that today's presenter is Sakshi and our expert is Hema. Hema worked with me in Reliance about 4 years before. And in fact, I still remember her presentation. In fact, when we were looking for the expert panelist, immediately I told my colleague Disha to check with Hema whether her availability, because she had made an excellent presentation at that point of time. And same is the case with Sakshi also. Sakshi and both Hema are both young, dynamic, and energetic company secretaries. And in fact, I asked her, Sakshi, let us not confine our discussion only with the regulation to where the definitions are there. Because apart from the regulation, the definitions in the insider trading regulation, there is certain other key terminology is there, which is very, very important, like trading plan, like designated person, window closure, contra trade, lot many things are there. So that's the reason we have given the caption for today's program as the definitions and some key terminology. So we are going to discuss all those things here. Now, as far as the topic is concerned, this is one of the most complex and complicated topic. Understanding the definitions and similarly handling this particular insider trading regulations. Even the most experienced company secretaries are also, as Hema has mentioned, make a fox pass, knowingly or unknowingly. Say, for example, what is an unpublished price sensitive information? Who determines that? It is the responsibility of the compliance officer. Anything and everything relating to insider trading regulations, it goes around compliance officer. So the compliance officer has to have a thorough knowledge about the subject. By merely reading it is not sufficient. You have to understand each and every word. SEBI as a regulator comes quite heavily as far as insider trading regulations non-compliance is concerned. Absolutely, they will be very ruthless. The reason for this is nothing but if any kind of non-compliance is linked with the stock market, the securities of the company in which either the insiders or the designated persons or the connected persons who are going to deal with and make some extra profit. And this extra profit they are going to make at the cost of others. That's why the regulator is absolutely ruthless as far as the imposition of penalties are concerned. Second thing is the compliance officer is under obligation to intimate the stock exchanges immediately any kind of non-compliance has taken place. That is another problem. So the compliance officer cannot hide the things. He cannot put that thing under the carpet. He has to intimate the audit committee. The audit committee has to initiate the action. And at the same point of time, what is the non-compliance? What sort of action the audit committee or the board has initiated, that also to be intimated to the exchanges. And according to me, this is one such what's called as a wrong thing which will be punished twice. That means any kind of non-compliance of insider trading regulations by a designated person, the company has to penalize him. In addition to that, if the regulator thinks that this penalty is not sufficient enough, they can impose further penalty also. So with this, I give a pause here and over the presentation of Sakshi, we will discuss it further. Thank you. Back to Deepti.
Good morning to all of you. I have a very great pleasure in welcoming you all, and on my own behalf and also as well as from Mehta and Mehta. As both the panelists have touched upon the point, the intricacies, what are the things has to be done, I will not get into those details. But the only thing is, I pick up a word from Sudhakar. Regulators are ruthlessly coming back on these issues. That is a word I pick up actually from him, what he said. Because we are all aware, you are all keeping in touch with what is the media, reading newspaper, etc. and all these things. So you might have actually seen when we talk this, all these terms, terminology, connected person, related party, immediate relative, all these things are all matter. Because what happened in the last year, if you would have seen it, probably early 2025, not the person who's in the company, but a former TV anchor and his family, he was actually penalized to the tune of around 6.1 crore rupees actually for using the privileged information which was available, and he was involved in the illegal profit making and trading. This is what it has actually happened. So that shows how the company should be careful in disseminating the information to the marketplace, even dealing with the other people, because the TV anchor is no way connected with anyway in the company, etc., either as an employee or in the connection of any consultancy, etc. And also he is a media person. That is what it has happened. You might have actually seen this case actually. Similarly, in another case, what happens is people get associated with the company after retirement. It has actually happened in case of the Adani Energy, I think, if I'm not mistaken, a former CEO and MD. He was actually associated with the company after his retirement along with his another consultant. So something has gone wrong. They were actually penalized much beyond 2 crore rupees. So the severity of the penalty, the way in which the regulators are coming, the things are all going on. It is really, really concern for all the listed companies, especially it is concerned with the company secretaries who are working. There are much more cases there. If you actually open SEBI website, you can see the cases, n number of cases are there. Penalties are very, very heavy. That is number one. Number two, as Sudhakar said it, that we are obligated to give the information to the SEBI what happened. Here what happened, unless in other regulation, there is no periodical reporting on this. There is no monthly reporting, quarterly reporting, half-yearly reporting, nothing is there. You have only the insider trading code. Company has to monitor, company has to ensure everything is done correctly. Something goes wrong, then the whole issue starts. How it has happened, what has happened, who is responsible, whether it is done, and all those things which actually starts. So in the light of that, we have to be careful very, very clearly. The company secretaries who are working with it. And another thing is there, when it comes to it, I think she will be discussing it when we go along it, how to identify the insider, what is the important, what are the precautions to be taken, all the things will actually come up. We will discuss elaborately. I think this series of the course will be definitely of immense beneficial to all. And Sudhakar puts it, we have done it about a few years back. Now, lately in 2025, the regulation has got amended actually by the SEBI. So with a reference to that, we'll have to get updated what is happening in the current day. I give a pause here. I'll ask our presenter to take us through the things in today's topic. And I also would like to request the participants, as usual, please put up your queries, etc. in the chat box. We'll be taking it periodically. And at the end of the session, subject to time permits, we will allow you to speak with the panelists and interact. Thank you.
Thank you, Mr. Bala.
I also would like to record my delightment at this juncture because I see the overwhelming response. Now it is showing around 219 people who are there, which actually show the urge of learning the topic. So I am very much delighted to that.
Morning, everyone. So today's topic, as we have all discussed, we are starting with a new masterclass on a SEBI Prohibition of Insider Trading Regulation 2015. And today we are starting with the very first topic, which is where we are going to discuss about the certain definitions and other key terminologies under the SEBI PIT Regulation 2015. So how we will be taking this presentation ahead is we'll be discussing about the legislative background and framework of the PIT regulations. Then we'll be discussing or emphasizing on the major important definitions like insider, connected person, UPSI, trading and trading plan, generally available information, and other key definitions which has not been part of Regulation 2 as a definition, but are very important terminologies to understand to really comply with these regulations, and then certain practical challenges and case studies. So to begin with, how this regulations came into picture and to understand the background and the framework is that SEBI had introduced insider trading regulations in 1992. That was the very first framework on the insider trading that was introduced by SEBI in 1992. However, these regulations had suffered from several shortcomings, and Then they were amended in 2002. That was the very first amendment after 1992. But still, it was better than 1992, but it was not as per the internationally accepted principles. So then in 2013, SEBI had it constituted a high-level committee on insider trading under Justice N.K. Sodhi, who was a former presiding officer of the Securities Appellate Tribunal. And that particular committee had recommended many, I would say, they had recommended internationally accepted principles, and they had in that particular committee had recommended properly the who is to determine who is an insider, definition, how to identify what is an UPSI, determination of the connected status, and they had also introduced the strict liability regime. After that recommendations, SEBI had introduced new regulations into January 2015 that was notified, and the effective date was May 2015. So since 2015 till 2026, there have been multiple amendments to these regulations, what we are going to discuss. And recently, I would say in 2024, the definition of relative had been added along with the immediate relative. So the difference has been identified by SEBI in 2025, the definition of UPSI has been amended, which has been increased to the ambit of UPSI to a next level. So in our presentation, we are going to cover all of those definitions. Now, to begin with, the first definition we are going to discuss today is a compliance officer, which is under Regulation 2, Sub-Regulation 1C. So, compliance officer has been defined under SEBI PIT regulations as is that person should be a senior officer who is designated as a compliance officer, and that compliance officer is required to report to the board of directors or the head of the organization, and is required to be financially literate. So your financially literate means that he or she need not to be a CA, CFO, CMA, or anybody of a finance professional, but that person who has been designated as a compliance officer should have the ability to read and understand the basic financial statements, which are the balance sheet, profit and loss accounts, and statement of cash flows. And that particular compliance officer would be responsible for the compliance of the policies, procedures, maintenance of records, all kind of monitorings of to the rules for the preservation of UPSI, and the trades which has been happening in the organization to monitor that and implement all the codes under these regulations to overall supervise the compliance of the SEBI PIT regulation. And I would say in a general parlance, compliance officer, generally the senior officer is the company secretary of the organization who has been designated as the compliance officer under PIT regulations, who in a way reports to the board and becomes the responsible for administration of the code of conduct and any work related to that, whether it's pre-clearance of the trades, accepting of the trading plan, monitoring of the contra trades, or closure of the trading windows.
Yeah, just 1 minute, Sakshi.
Yes, sir.
See, this compliance officer, as Sakshi has mentioned, unlike listing regulations, SEBI listing regulations, the compliance officer need not be a qualified company secretary. What it says is any senior officer who has been designated as compliance officer for the purpose of insider trading regulations, he can continue as the compliance officer. So under the listing regulations, you may have a compliance officer. Under the insider trading regulations, you may have a different compliance officer. But to a large extent, I mean, almost all the companies are having the company secretary only as a compliance officer. In fact, some time ago, somebody asked me, what is the reason for this? Why under the insider trading regulations, they have not asked that qualified company secretary to be the compliance officer? Might be at that point of time, the understanding is since this subject is itself a very vast one, because all the trading activities are to be monitored closely by the compliance officer to be able to control that. And similarly, the insider trading code is also to be established and ensure its compliance by the designated persons and their relatives. So the responsibility is enormous. Might be SEBI might have thought in its wisdom that Okay, let some other senior official may be appointed as a compliance officer. So not necessarily both these positions are to be held by one person only. So in case if any, suppose major companies, big companies like maybe Reliance or Tata's or Mahindra's and all these kind of companies where the number of designated persons will be more, they may consider having this kind of compliance officer who is separate as far as the insider trading regulations are concerned. But to a large extent, as I have mentioned, company secretary continues to be the compliance officer. Yeah.
There is actually a question has come actually. Is there a comprehensive list of what all would be on UPSI? Not asking for an exhaustive list though. That is what Shankar Iyer has actually asked. Actually. In fact, really speaking, when we talk about the insider trading regulation, it simply says any information which is actually known to the public, which is held in the privately about the company securities or business, etc., and all this, which will
Well, when
actually
we
cause.
discuss UPSI definition, that point of time, all these things will come
We
out.
just started. Just let the
Yeah, it just started. Yeah.
Okay. Yeah.
So the next definition, what we are going to discuss is definition of an insider, which has been again defined under Regulation 2, Subregulation 1G of the PIT regulation. So insider has been defined as any person who is a connected person, which is one side, or in possession of having access or having access to UPSI, unpublished price sensitive information. We are going to discuss in detail what is UPSI at the later stage of our presentation. However, once to understand the definition of an insider or to understand how can one person be an insider to an organization is either of the or has been given here, that there are two sides to determine how a person to be an insider. Either one person has to be a connected person, which definition of connected person is also we are going to discuss after this definition. So if any person is falling in the definition of a connected person, irrespective of the fact whether they are actually in possession of a UPSI or not, or having access to UPSI or not, that person will always be considered as a connected person. So we can say that every connected person is an insider. Along with that, if any person who might not be a connected person, it's not mandatory, but is in possession or has access to UPSI at any relevant time, would be considered as an insider as well. And these both the limbs are operating independently. I mean, it is not required that one person has to be a connected person and then having access to UPSI would be an insider. So insider is more vast than a connected person, that all the connected person would always be an insider. Along with that, if any other person who might not be a connected person or might not be related to organization in any ways, but having access to UPSI would be considered as an insider for that particular time period. He's having that having access to UPSI. We have I've tried to explain it through some examples. For example, like if there is a CFO of any company, let's just say ABC Limited, that person is connected by his or her designation. So CFO would always be a connected person, would be a DP designated person. So that person would always be an insider, irrespective of the fact that that person is having access to UPSI. The second becomes, let's just say that whenever we send some documents to an printer employee, and that person accidentally receives the draft of the board resolution with the UPSI, that printer employee becomes the insider on receipt of that board resolution for that particular time period. The UPSI is not a public information. Similarly, any research analyst of a merchant banker being the intermediary, is always a connected person. So any research analyst of a merchant banker who receives the financial projections, which is a UPSI, becomes an insider through both the ways, that one, he is a connected person, second, he receives the UPSI. And in case if that happens, like in a situation where any public person who is not related to the organization trades in the shares or the securities of any company on the basis of a rumor. So it has been very clearly mentioned in the regulation that rumors are not considered as a UPSI. So that particular person who has been trading in the securities of that company is not having any access to the UPSI, and he does not have any access to the insider status. So that person would not be considered as an insider on the basis that merely that person is trading on the in the securities of the company on the basis of rumor. So this is how it is. Other than that, we are going to discuss the connected person, the intermediaries, the UPSI to understand that better in detail.
Sakshi, here I would
In this
like to
case,
add.
sorry, Hema, go ahead, please.
Sakshi, here I would like to add that even the person who is not belonging to company in any way, but since this question has come up that if an outsider, not a connected person, who while on a business visit to the office of the company hears some information, whether it will be and he execute a trade, whether he will be called an insider. So that person will definitely be an insider irrespective of whether he induce or he accidentally gets that UPSI, and even the public servants are included in this definition. So once a person is in possession of UPSI, irrespective of fact how he came into its position, he will be an insider because he have that extra information which is not available in public. And the very intent of this insider regulation is that fair uh, game should be done, level playing fields for all players in the market. So obviously one having that extra piece of information which is not publicly available will always be an insider.
Yeah.
Yes, sir.
Just further to add whatever Hema has said, that all the designated persons who are like directors and employees of the company, who have been designated as the designated persons, they're all insiders only. In addition to that, the connected persons. Who is a connected person? That next slide, I think the definition will come. But how to prove that if there are insiders, I mean, the designated persons are there, it is very easy because they are on the payroll of the company. But how to establish who is a connected person, on whom the onus is there? The onus is on the person who is making the allegation that he has dealt with in the securities of the company based on the information available with him. So whether he is a connected person or not, suppose, say, for example, tomorrow if SEBI says that you are an insider and you have dealt with based on the UPSI you have dealt with traded in the market, it is the responsibility of the SEBI to establish that he is the connected person. So SEBI normally what they do is they have, based on the stock exchanges, they have very strong surveillance departments. Whenever there is any kind of volatility in the price of that company's securities, definitely they will keep a tab on that. And the moment they come to know some kind of insider trading activity is taking place, they will watch that very closely and immediately they will furnish that information to SEBI. And then, of course, that's how the things have started taking place. Please remember that SEBI is also, and even the exchanges, they're keeping a track on the social media also. Establish whether the person is a connected person or not when two people are dealing with that. And so, in fact, at one point of time, one case has taken place about 4-5 years before. There are two companies, and then they both are friends, and they have traded in a particular company's listed company securities. And SEBI has said that it is an insider trading activity. Both these people have said that they don't know each other. However, SEBI could produce the evidence of these two people making a holiday based on their Facebook photographs. So SEBI is keeping a tab even on the social media also, simply by saying that I have no idea, I'm not a connected person and all will not do. But as I have mentioned that onus is on the person who is making the allegation. At the same point of time, the connected person who has been asked to show the cause why he has not to be penalized, he certainly got a rebuttable this thing, the grounds are there. Based on that, he can always rebut. Yeah, Sakshi, go ahead.
So, Gagan, to add to your point, people who are interested, they can actually read the decided cases of 2025 that I was mentioning about the TV anchor. The case is actually titled as the Kemal that the Jaya guy. That is the case which was actually there. who no way connected, who was an outsider, and he actually had the privileged information. He dealt with it. He made the profit, illegal profit, etc. In that particular case, the heavier penalty was whatever the profit he has made, amounting over 6 crore or something, that was to be returned. And again, the family was actually penalized for about 1 crore rupees. So this is a very interesting case how they have actually established the person, as you rightly said, no way with the company, no way connected with any capacity of the company, the consultant or otherwise also, but only a media TV anchor, how he has come, how the SEBI established. It is a very interesting case that people can go through this case that will give a fair idea about it. Yeah.
Correct.
The next definition, what we are going to discuss is the definition of the connected persons. As Sudhakar sir has already mentioned, this is a very wide definition in a way. So the connected person, how it has been defined as any person associated with the company, either directly or indirectly in any capacity during the 6 months preceding the relevant date, or immediately related persons of such persons. So here we are going to bifurcate in these two parts, like any person who has been associated with the company, whether the employees or the definition. I mean, so we have to really understand how the person becomes a connected to the organization, and indirectly as well, if they are in the business or however associated with the organization during the 6 months preceding to the relevant date. So they do not need to be the employee or the association as the association or the employment as on that date. In fact, if they have been associated with the organization during the last 6 months as well, they would be considered as the connected person for that particular organization. Along with that, and the immediate relative of such persons would also be considered as the connected person. After that, in regulation 2(1)(d) second clause 2 has defined the certain people who will be deemed as the connected persons, irrespective of the fact that any other thing, like, if they have been having access to the UPSI or not, they would be deemed connected person for these regulations. So that would include the relative of a connected person, as it has already been defined in the definition. It has written immediate relative, but in the deemed connected person, they have also includes the relative of the connected person. SEBI has defined relative and immediate relative as two different definitions in the regulations. Any holding company, associate company, or subsidiary company of that particular organization would also be a deemed connected person. Intermediary, as specified in Section 12 of the Act, or an employee or director thereof. So we will be going to discuss who is considered as the intermediary or fiduciary for these regulations. But if there is any employee or the director of those intermediary or fiduciary would also be considered as a deemed connected person. Any investment company, trustee company, asset management company, or their employees or directors. So any organization which is associated, their employees and directors would also become the connected persons. Any official of the stock exchange or clearing house or corporation. So the stock exchanges and the clearing corporations are always considered as a connected person. Member of the board of trustees of mutual funds, member of the board of directors of the asset management company of a mutual fund, or is an employee. Any member of the board of directors or employee of a public financial institutions. Any official or employee of the self-regulatory organization recognized or authorized by the board. Banker of the company, concerned firm, trust, Hindu undivided family company, or association of persons wherein a director of a company or relative or banker of the company has more than 10% of the holding or interest in the organization. A firm or its partner or its employee in which the connected person specified in the clause 1 of clause D is also a partner. So that refers to the investment company, trustee company, and asset management company. A person sharing household or residence with a connected person specified in subclause 1 of clause D. So this definition, it is written over here is already been mentioned that this person would always be deemed as a connected person for the organization. If the organization feels there are more to it, they can add on to this definition, but they cannot delete any of this from the definition of a connected person. However, there has been a explanation or note which has been given by the SEBI under these regulations is that it is intended that a connected person is the one who has a connection with the company, and that is expected to put him in possession of UPSI. So the only intention of SEBI putting these many people in the definition of a deemed connected persons or the connected person is only mere on the assumption that these person are expected to have in possession having the UPSI, but that does not mean they will always be having the UPSI with them. It is not mandatory that since a person is a connected person will always be having having access to UPSI. So the relatives and the other categories of the person specified above are also presumed to be connected person, as we have discussed, but such presumption is a deeming legal fiction and is rebuttable. If the person says and they do not have any access to the UPSI, and it has been proved to the fact that they were not having access to any UPSI for that matter, is they are not considered, connected for that time. Only this definition was made to bring into ambit the persons who may not be directly related to the organization, and they do not occupy any position in the company in the regular course of the business, but somehow they are indirectly connected to the organization, and they might be aware of the operations of the organization, and through that they might be having access to the UPSI. Just to preserve that, SEBI has made such a big definition of the deemed connected persons. And let's just take an example here that Mr. Sharma, who is a partner at the statutory firm of XYZ Limited, complete the assignments and move to a different firm. 4 months later, he does the dealing in the shares of the XYZ Limited. So in that situation, Mr. Sharma would also be still be a connected person. Yes, he will be a connected person because there is a time clause of 6 months. If any person was in the employment or was related to the organization for the last 6 months, he would be considered as the connected person. So because he has traded in the during the only within 4 months of leaving the organization, it is presumed that he might be having access to the UPSI. He might not having, but it is presumed that he might be having access to the UPSI and is considered as a connected person. If any person who resigned as a director 5 months ago would also be a connected person, the 6 months time period needs to be clearly monitored. And the practical challenges happens while identifying the connected person, because first to track the ex-employees within the 6 months window is quite difficult. The more difficult part comes to when we have to identify connected persons at a third party vendors, their IT, legal, VR team, because they are not aware of their own status that they are considered as connected for that particular organization. And rebuttal of presumption is considered as difficult because it is a burden on the connected person to explain that they did not possess any UPSI if any trade has been done by them.
Yeah, 1 minute. Let's go to it. See, just to see the connected person's definition, it says that very clearly any person who has been associated with the company directly or indirectly. That is very important. It not necessarily it is to be directly, even indirectly also. That indirectly means it may be a chain also completely, not necessarily one-to-one. Somebody might have shared the information, but that somebody might have shared information with 3, 4 people more also. So all of them will become that time connected persons in any capacity. So capacity may not necessarily you have to be in the employment. You may be an employee, you may be a consultant, you may be a vendor. That actually Sakshi has mentioned that who are all the people who are deemed to be connected persons. That is not an exhaustive list. That is only an indicative list. These are all the people who are deemed to be connected. So we to just simply understand that if any person get an unpublished price sensitive information, whichever the way it may be, if he get that information, based on that, if he has dealt in the market and has made profits or losses, whatever it may be, not necessarily you have to make profits only, but if you have traded in the securities of the company based on that unpublished price sensitive information, you will become a connected person. Several times I have been asked a question that how can the compliance officer control the activities of these connected persons? Because he has no clue about that. To answer that question, the responsibility of the compliance officer is only to regulate the designated persons and their trading activities. If any designated person has traded in the market based on that unpublished price sensitive information, or if he had made any non-compliance, then he has to ensure that necessary compliances are there, necessary reporting is there. As far as the other connected persons are concerned, or insiders are concerned, that means who are outsiders, that is not the responsibility of the company, that is the responsibility of the regulator, that is SEBI. Yes, Sakshi.
Sir, I would like to add few points here. Recently, I would like to take up this deemed connected portion, because recently there was amendment done by the SEBI which was effective from 6 December 24, and here the definition of relate in deemed connected portion, earlier it was coming immediate relative and it was replaced by the relative word. And secondly, the firm partner in that firm, employee in that firm, where connected person is partner, as well as the person who is sharing the common residence was included. So the rationale behind this was the regulator find that it's not only that person comes in position of UPSI only when the person is financially dependent, or the person's takes the trading decisions from the connected person, but many times it's out of love, affection, common proximity, close relationship, and cohabitation. So this was found by the regulator that yes, these are also the situations where UPSI got passed to some persons. However, earlier these persons were not in the pool of connected deemed connected person. So the burden was on SEBI to prove that these persons have access to UPSI. Gained experience made SEBI make this amendment that yes, these persons should also be included in the list of deemed connected person, so that it hits the two bull actually. It deters the trading done by the persons not directly through immediate relative but by the third party, which SEBI had tried to capture. And second thing, now SEBI get the larger pool of connected person to investigate. And coming from the company's point of view, it has not increased any compliance burden on company, because company, as Sudhakar sir rightly said, that as a compliance officer, we are supposed to only monitor the trading activities and other compliances pertaining to designated person. However, when SEBI investigate, so this list comes into picture only for the purpose of investigation which the SEBI will deal with. And however, it's not that we should create awareness among the designated person that now, though you are not supposed to give list of your deemed connected person, but in case some charges are being leveled, then these persons will also be included. Yes, so we can
Yeah.
go ahead.
So what Hema is trying to say is, if I am not wrong, that since under this definition has been amended, and they said that these are all the people who are deemed to be connected, that means now the onus is on the other person to establish that he is not the connected person. Earlier, what happened was it was the responsibility of the regulator to establish that you are the connected person first. After that, the question of dealing with that in that based on the FCA and all, that is a secondary issue. Whereas now what happened is, because of this amendment in this connected person definition, The onus is on the person to establish that I am not a connected person. Though I am supposed that okay, by the residential address might be the same. That doesn't mean I am a connected person. Earlier, what used to happen was there are n up to number of people having the same residential address, dealing with the shares and all. But they used to say that, look, we have no relationship with each other. We have nothing to do with each other and all those things. Now, what SEBI says is if the residential address is the same, you are deemed to be connected. Whether you are connected or not, now you have to come and establish that you are not connected. So now the ball is on the court of the other persons. So one has to be very careful when you are saying that if whenever any kind of trading takes place, say for example, this even in case of a relative also, your spouse is your immediate relative, your children are your immediate relatives. Can they trade in the market and you are responsible or you are not responsible? So they are basically deemed to be connected persons. Now, if they are financially not dependent upon you or they are not taking advices from you for the investment in the stock market, that you have to establish it. Then only you can be out of the net. Otherwise, you will be inside the net only.
Yes.
Yes, Sakshi, go ahead.
So now we will understand the definition of immediate relative. So immediate relative, as we know, means a spouse of a person and includes the parent, sibling, and child of such person or of the spouse, and any of whom is either dependent financially on such person or consult such person in taking decisions relating to trading in securities. So immediate relative has been defined again, has been bifurcated in two parts, that the spouse of a person would always be an immediate relative, but the other people like the parents, siblings, and the children would be considered as an immediate relative only if they are either dependent financially on the person, or they might not be financially dependent, but they consult such person for the taking decisions relating to trading in securities. So if any of these condition is fulfilled, that the person would be considered as an immediate relative. So here financial dependence is not related to only a blood relation. I mean, financial independence is required to be uh, ascertained here to understand if some person is an immediate relative. And in case the adult child is earning independently, that person might not be an immediate relative. Let's just take an example here. If there's an adult child who is earning independently, and but he consults his parent for taking decisions relating to trading in securities, then he becomes an immediate relative. But in another scenario, the adult child is earning independently and does not consult the such person in taking decisions relating to trading in securities, then both the criteria are not fulfilled and he's not considered as an immediate relative. Though he's a blood relation, he's a child, but he would not be still considered as a blood relative for this regulation. I mean, he would not be considered as immediate relative for these regulations. Now, yes, sir.
Sakshi, when you say consulting, not consulting, and other thing and all, it's okay. But establishing this fact, how easy, how difficult it will be.
It would be very difficult. I would say, how would you be able to justify if
Correct.
there has been no discussion with respect to the transactions, as ma'am has mentioned, Hema ma'am, that out it is not generally out of any transaction. Sometimes out of love or affection, you tend to discuss certain things, and you might be able giving certain information with respect to trading or dealing in the securities. So that is a very difficult task to actually identify.
See,
Because why I ask this question is, we had one director. His brother, he was actually buying and selling the share, the trading in the share. I was actually marketing, and it was happening. When I contacted them, he told, "I don't know what he's doing. I have no connection at all. Don't ask me anything about him."
see, Bala, by simply saying that it's not sufficient, that's why they brought this what's called as immediate relative definition and the connected persons definitions also. the immediate relative is to be a connected person, because to the the immediate relative of the designated person is a connected person. So as I have mentioned that the moment you are a connected person, SEBI will say that you have dealt with and you have traded in the securities of the company based on UPSI. Now it is for you to establish that you are not a connected person. This is what precisely I told. So SEBI need not establish that whether you are consulting that person or not consulting the person. It is for you to establish that you are financially independent and you are not what's called as consulting the designated employee for any kind of investment activities. So, for example, if you are staying in the same residence, suppose my children, I am working for Reliance, suppose my children are there, and suppose both are in the medical profession and they are investing in the stock market. And suppose, by the, see, whenever the kind of SEBI is going to catch a person for the insider trading activity, they don't just make the allegation like that. They will keep a watch on the activities, that is called as surveillance. So based on that information available with them only, just like any kind of investigative agency, SEBI is also more or less a kind of investigative agency. So they will make that thing by you have done this insider trading. Now it is up to you to establish that you have not done the insider trading. Okay. So it is not for SEBI to go and do the witch hunt. It is for you to establish that you have not done that. That is the reason, the moment your immediate relatives or your relatives are there, you have to ensure that if you are a designated person, keep arm's length distance. At the same point of time, you should be able to establish it also. Let me tell you that I have two daughters, and one daughter is a chartered accountant and second one is a lawyer. Both of them were working in different entities, and that I was working for Reliance, my daughter was working for ENY, another one working for Mondelez. I told them very clearly, never ever talk about your company or your clients to discuss with me at home. And I never used to discuss about my companies with my children. The reason being that it is simply that it's very easy for anybody to establish that we are exchanging the unpublished price sensitive information. Any kind of trading done by any three of us will going to catch our neck, and it is the onus is on us to establish that we have not done that activity. So better to keep arm's length distance. If in case God forbids you have to establish, you should be able to establish that. Yeah. Yes, Sakshi, go ahead.
Definition which comes as the definition of relative, with, as we have discussed in year 2024, SEBI has introduced this new definition, which is definition of relative other than immediate relative. So relative will include spouse of the person, parent of the person and parent of the spouse, sibling of the person and sibling of the spouse, child of the person and a child of the spouse, spouse of the person listed at clause 3, which is the sibling, and spouse of the person listed at clause 4, which is child of the person. So this definition has been, it is intended that the relatives of a connected person to become the connected person. So that's how the relatives has been defined here, and it is quite vast than the immediate relatives. And again, it is a reputable presumption that the connected person had the UPSI. It has been explained again that it is just a presumption that they will be having an access to the UPSI. They can always prove it, as they did not have any access to that. Now, the major definition, what we have to discuss under these regulations, the definition of UPSI, unpublished price sensitive information. So as it has been defined in these regulation, it means any information relating to the company or its securities directly or indirectly that is not generally available and which upon becoming generally available is likely to materially affect the price of the securities. So here it has been defined, or I would say if we bifurcate this particular word, unpublished price sensitive information, it says any information which is unpublished and price sensitive which refers to unpublished, refers to any information that has not been made generally available to the public. I mean, if let's just take an example, if I have an access to the any UPSI with respect to any organization would not make it public unless the company has put a disclosure on the stock exchanges or on its website, which would be considered as a public information. It would remain as an unpublished information. And price sensitive means whenever the information becomes generally available to the public, it is likely to materially affect the price of the securities. It is not mandatory that it will affect the price of the securities. It may or may not. So, but if it is likely to affect the prices, it is a price sensitive information and it has to be related to the company. And which includes any directly or indirectly. I mean, it becomes a very wide scope, but if any information related to the director of the organization, sometimes that also becomes the UPSI for that company or the KMP that we are going to discuss because earlier the list of the UPSI was not too big. It was inclusive of the financial results, the dividends, change in the KMP, mergers, acquisition, demergers, any fundraising, new product launches. However, SEBI widen amendment regulation 2025, which was effective from June 10, 2025, they have increased the ambit of unpublished price sensitive information, and they have clearly written that this list is again an exhaustive list, and that shall ordinarily be including but is not restricted to. Information relating to the following would always be considered as a UPSI. So if any organization who feels that they have further other information that they would want to consider in the list of the UPSI, they may add it here. So it is financial results, dividends, change in the capital structure, mergers, demergers, acquisition, delistings, even the disposals and expansion of the business. Here it is very important that mergers, demergers sounds very big. But if any organization is expanding its business, that is also very considered as a UPSI. For example, if they are just adding one unit or disposing one unit, that would all that information relating to that unit expansion or disposal would also be considered as an UPSI. Award or termination of orders, contracts, which is not in the normal course of business, and such other transactions. Change in the key managerial personnel, other than due to superannuation or end of the term, which has been already public information. So, any other changes in the KMP, appointment or resignation, or even death and resignation of a statutory auditor or secretarial auditors. So the auditor's resignation has also been included here now. Earlier it was not there. Change in the ratings other than the ESG ratings. So it has been clearly defined. If there is any change in the ratings other than the ESG rating would be considered as a UPSI. However, in the certain situations, it happens the company is reaffirming their ratings. It would not be a mere UPSI if there is no change. Fundraising proposed to be undertaken. So in case we do not see, like, if the company is raising the funds, then only it would become an UPSI. If the proposal is also made to do the fundraising, it would be considered UPSI at that stage itself when the proposal is made. Agreements by whatever name called, which may impact the management or control of the company. This has become a very wide scope now. Any sort of an agreement needs to be clearly, I would say, reviewed. If in any way they're impacting the management or control of the company, has to be considered as an UPSI. Any fraud or default by the company, its promoter, director, KMP, or subsidiary, or arrest of KMP, promoter, or director of the company, whether occurred within India or abroad. As we had discussed, any information which is relating to the organization directly or indirectly. So here, any fraud which has been not made by only company directly or their promoter, even the KMP and the KMP, promoter, director of the subsidiary are also inclusive here. For considering that information as a UPSI information, any resolution plan restructuring or one-time settlement in relation to loans, borrowings from banks, financial institutions, admission of winding up petition filed by any party, creditors, and admission of application by the tribunal filed by the corporate applicant or financial creditors for initiation of corporate insolvency resolution process against the company as a corporate debtor, approval of resolution plan or rejection thereof under IPC Code 2016, initiation of any forensic audit by whatever name called by the company or any other entity for detecting mismanagement in financials, misappropriation, siphoning of or diversion of funds, and receipt of financial final forensic audit report would be considered as a UPSI and would require a disclosure. Action initiated or orders passed within India or abroad by any regulatory, statutory, enforcement authority or judicial body against the company or its directors, KMP, promoters, or subsidiary in relation to the company. Any outcome of the litigation or dispute which may have an impact on the company. Giving guarantees or indemnity or becoming a surety by whatever name called for any third party by the company, not in the normal course of business. Granting withdrawal, surrender, cancellation, or suspension of key licenses or the regulatory approvals of the organization would always be considered as a UPSI. And along with that, it has been written in these regulations that, as we had discussed, this needs to be a material information as well. So along with these information, it would always be considered as an UPSI, irrespective of the fact there are certain other informations relating to the organization which are which needs to pass the materiality test. So for identification of the events as the UPSI, other than these, the guidelines for materiality referred in para A of part A of schedule 3 of SEBI LODR would also be considered as a UPSI, and materiality has been referred under para B of part A of schedule 3 of LODR. These two things would also be applicable on any listed company for considering if any information is a UPSI for them.
1 minute, Sakshi, go to that. Sudhakar, here we should give some example, like this award or termination of contract not in the normal course of business. So actually, any contract, it will be pertaining to the business, but if it is of a very material big nature, which will impact. So this way, some points, if you both can give, I think that will give more clarity to participants.
Yeah. So just go back to the previous slide, Sakshi. Yeah. See, if you see the definition, what it says is unpublished price sensitive information means any information. So when we are reading this, it is to be read like this. Any information means any information, not necessarily it is only a financial information or a legal information. Any and every information about the company or its securities, directly or indirectly, that is not generally available, which upon that generally available means it is not available in the public domain. It is available only to a few people who might be connected or not connected to the company. Not connected to the company means, suppose, for example, they are not employed, but they are intermediaries. The information is available with them. Upon becoming generally available, it is likely to materially affect the price of the securities. As Deepti has mentioned, suppose just now, there is a kind of a big, huge contract has been awarded to the company, which is to be executed over a period of 3 to 5 years. That means the next 3 to 5 years, the company has a very bright future. Obviously, it is going to have an impact on the stock price. But at the same point of time, say, for example, after 6 months, that contract has been cancelled for whatever the reasons it is. Suppose fraudulently it is obtained, the tender got won, whatever the reason it is, and all that got cancelled. Again, it is going to have a huge impact on the price of the share of the security, whichever it is the case. So in both these cases, what happened is that is unpublished price sensitive information. That's why I told in the beginning itself, it is the responsibility of the compliance officer to determine what is unpublished price sensitive information. In fact, prior to this definition, at one point of time, all the issues which are connected with Regulation 30 of LODR were deemed to be an UPSI. Subsequently, that has been amended and has been removed. Now they have brought back the thing. But the only thing is, they have not said every information under Regulation 30 is not going to be an UPSI, but they have picked up a few major issues and they said that not necessarily this is the evidence, but again, the same thing, it is an indicator, huge laundry list, which in the next slide, Sakshi has narrated just now. So
Next.
what, as a compliance officer, what you need to understand is, they said that it shall ordinarily including but not restricted to. That means what? This is only an indicative list. This is not the exhaustive list. So as a compliance officer, it is up to you to determine that what is an UPSI and what is not an UPSI. Why you have to determine, why it is important? The reason being, the moment it is an unpublished price sensitive information, if you are determining so, you have to close the trading window for those employees who got access to that information. They are not supposed to trade in the securities of the company during that period, which they are, unless until that information has been made generally available. Say, for example, a merger proposal is there. It is contemplated between the CEO and the CFO of the company. So there are two people with whom that information is available. So it is their responsibility, of course, though we will discuss it in the future webinars, just to understand that UPSI. So it is their responsibility to make an entry in the SDD, Structural Digital Database. Sometimes it may so happen the compliance officer of the company may not even come to know what is this UPSI. So it may be, that's why if you read the insider trading regulations, as far as entry in the SDD is concerned, it is not the responsibility of the compliance officer. It is the responsibility of the board of directors to ensure that the maintenance of structural digital database and the entries made therein. The responsibility of every person who is having that information, who is, whether he is accessing it or whether he is sharing it with somebody, they have to ensure that proper necessary entries are made. It may so happen that companies, they might be sharing with the compliance officer so that he will be able to take care of this, SDD entries and other things are concerned. So determination of UPSI is very important. At the same point of time, by merely the compliance officer know what is an UPSI, that is not sufficient. He should sensitize the other designated persons that in case you are having this access to the UPSI, how they have to handle that. That is also equally important. In fact, I always used to say that UPSI is like a burning charcoal. Whether you knowingly or unknowingly, intentionally or unintentionally, if you touch that, you will burn your hands. Same is the case with UPSI also. You have to handle that very carefully, like a burning charcoal, when whatever the precautions you take it while handling that burning charcoal. Same is the case with UPSI also. In fact, we will discuss it in the next webinar, that Regulation 3 and 4, wherein it says that procurement of UPSI as well as sharing of UPSI, it should be only for legitimate purposes. And while sharing the information, you have to say that this information is an unpublished price sensitive information. This is how that is to be handled also. Another thing which may come is that under Regulation 30, you are supposed to inform to the stock exchanges certain material information. As I have mentioned that everything under Regulation 30, not necessary it is an UPSI. So when it will become an unpublished price sensitive information, that is the responsibility of the compliance officer to determine and accordingly close the trading window. Another thing is that sometimes the question comes whether it is confined to the company only or the information may be germinated from the subsidiaries or material subsidiaries of the company also. That information, as I mentioned to you, directly or indirectly means that even if some information might be relating to the subsidiaries or material subsidiaries, but that is going to have an impact on the share price of the company, then even that information also becomes unpublished price sensitive information. That is the reason that not necessarily the employees of the company only are to be designated as designated persons. Even the people within the group, maybe subsidiary employees or associate company employees who are having an access to the information of the UPSI, they're also to be made designated employees of the company. Yeah, Sakshi, go ahead.
Sakshi, if you can go back, I will also like to touch upon 2 points further to what Sudhakar sir has said. Uh, Most of the questions pertaining to UPSI we get is when is UPSI said to be germinated, and second, confusion is always there in the mind of professional that whether all the illustrative list which has been given definitely means it's a UPSI and we have to do all the compliances, closure of trading window and everything. So coming to first, germination of UPSI cannot be restricted to only the board meeting announcement, but it starts right from the time and when the probability of going ahead is always higher than probability of not going ahead with the event. So that is exactly the point of consensus when it has been reached by the management right there that UPSI has been generated. Now post compliances follows for its implementation. So for example, if the board has decided, not only board, even prior to board, the management has decided to go for the bonus issue or dividend, and in board meeting that decision has been deferred, but that doesn't mean that UPSI has been deferred. UPSI is germinated right when the management decided to go ahead with the corporate event. So germination of UPSI starts right when the probability of going ahead is determined. Secondly, this illustrative list has been elongated by the SEBI recently with effect from 10th June 25. And Sudhakar sir rightly said that in the starting, material events were part of this illustrative list. However, it was felt by the regulator based on the experience gained and the market feedback that not all material events are UPSI. So the list was, the material event was deleted from the definition of UPSI. Now, after further this experience gained, the regulator was able to find, and it was there in this SEBI board note that the companies was only assuming the illustrative list and informing it as an UPSI, and rest all events were not considered. Considering this, the proposal was made that this UPSI definition will again contain the definition of material event. However, not all material events are UPSI. So this illustrative list was given by SEBI, which is linked to the materiality threshold as mentioned in SEBI LODR. But the real test still remains the same. There is no change in that this information is likely to materially affect the price of securities. So this list is the illustrative list. It can't be said to be the prescriptive one. Once the event is finding place in that list, it's definitely UPSI. It's always the compliance officer management who have to decide based on case to case whether it's UPSI or no UPSI is there. For example, if a company decides to acquire 49% of shares of another very small company, so from point of view of a listed company, if it's going to invest 5-6 lakhs in a very small company, it's not going to be UPSI because it's not going to materially affect the price of security. So it depends upon the case to case basis. This is what I have to say. Yes, actually, you can go ahead.
So as I have mentioned that the under the responsibility of the compliance officer is to sensitize about the significance and importance of insider trading regulations across the organization. Number one. Number two, especially in case of senior managerial personnel or key managerial personnel, he should be ensure that the necessary entries have to be made in the structural digital database. So as I have mentioned that At the inception stage, the compliance officer might not be having access to that UPSI. He might not even be knowing that. As I have mentioned earlier, that suppose the CEO and the CFO are contemplating a merger proposal, a takeover proposal, or an investment proposal. So anything may happen. So initially, when you are conceiving that idea, it may be among the executive directors, maybe executive directors with the CFO of the company. Like that, then it started one to one like that. It gets further examined by the people concerned. The moment the compliance officer comes to know that this unpublished price sensitive information has been germinated, it is his responsibility to check the SDD entries, whether they have taken place or they have not taken place. Then it is also his responsibility to check with the concerned top management people that who got the access earlier, why the necessary entries have not been made. If it is a non-compliance, obviously it is his responsibility to bring it to the notice of the audit committee or to the board, whatever the case may be. He cannot simply shut his eyes that even if the entries are not made, now you are making the entries. It is not so, because again, the same thing as I mentioned to you, the purpose of SDD, though we will discuss in future webinars in detail, but the purpose of the SDD is nothing but audit trail. Whenever any kind of trading activity takes place based on the UPSI, the purpose of maintenance of SDD is that regulator wants to see the audit trail. That means when the information was germinated and how the information has been passed on from one person to the other at what stage and when the trading activity has taken place. All these things will be correlated and the dots will be connected. Yes, Akshay.
Well said, Sudhakar. Actually, one of the participants, Mania Srivastava, has put actually, when UPSA germinates, identifying the UPSA along with the starting point is equally important. However, SEBI has given the different ruling in the different cases as to starting point of UPSA, how the company can defend itself in such a situation. That's what he has actually put. Really speaking, it is up to the company's responsibility to have a framework actually put in place. Today, we are all talking about SDD. I am talking about 2 decades ago when SDD was not there actually, but insider trading code was there. Because insider trading now traveled a very long ways, many amendments have come. But way back, I am talking about 2004 and 2005. What we have done in our organization, as you rightly said, company secretary doesn't know. That situation is more or less avoided in our company. Any major discussion, any senior man meeting, the company secretary is always an invitee to participate there. That is number one. Number two is that we also established the policy, two things. Any information, how to identify what is to be done, number one. Number two is, again, we also have the dissemination of the information to the marketplace. Who are authorized to do, who can actually disseminate, who cannot, and all those things. Those policies were also there. So it is, as you rightly said, it is very important on the company's point of view to put up the framework. That is one thing. And again, you touch upon the SDD. SDD is actually a real-time entry. I don't think entry can be made after the event gets over or something like that and other things and all. It is always the real-time entry. That is one. And second thing is, you also said one of the point, awareness. This we always used to have even those days. Any changes, any amendment, etc. We used to always have an indoor meeting, and we used to also bring the awareness. What is the thing? What are the do's? What are the don't? Not only that, we also evaluate what is required from the board or anything required further. Those things also used to be discussed. So company has to put up a system in place. That's what I think. Yeah. Yes, Sakshi.
So the next definition which comes is the generally available information. So the information that is accessible to the public on a non-discriminatory basis, which means published on the stock exchange platforms, company website, or CB database, is a generally available information. Any information which is being shared selectively, even with the large number of person, cannot be considered as generally available information. We'll see like how the one simple information is a UPSI, and after being available, it becomes a generally available information, like the financial results. Till the time the board is approval has been received for those financial results, and the outcome is being filed with the stock exchanges, the information is considered as a UPSI. The moment filing has been made with the BSE or NSE or whatsoever is the stock exchange, the information becomes generally available information. Similarly, with respect to the dividend decision, uh, analyst call transcript, these informations till the time the board resolution has been passed, it is considered, I would say, till the time it has been disclosed to the stock exchange, it would be considered as a UPSI. The moment the information is being disclosed to the stock exchanges, it becomes a generally available information. Even for the analyst call transcript, the information has been given to the certain analyst right after the board meeting, whenever the calls happens. The information has been selectively shared with the shared with certain analysts is still a UPSI unless the public disclosure has been made with respect to that particular information. Then only it becomes a generally available information. CEO change, any new product launch, or any there is a court order against the company, or there could be numerous reasons, or the, I would say, incidents wherein an information is considered as an UPSI till the time any public announcement has been made. The moment the public announcement, whether by way of press release, by way of stock exchange disclosure, by way of putting it on their website or disclosing it to the regulator, the information becomes the generally available information. Now we discuss here about trading, which has been defined again under Regulation 21L. Trading means and includes subscribing, redeeming, switching, buying, selling, dealing, or agreeing to subscribe, redeem, switch, buy, sell, deal in any securities, and trade shall be construed accordingly. So the trading has been defined as a very wide definition under these regulations. Earlier, we used to be of an opinion like, unless the actual buy or sell has been done in a particular securities, then only it would be considered as a trading. Now, but the SEBI has clearly defined that trading includes everything. If you're subscribing, if not, the trade has not happened actually, it has been redeemed, it has been anything has been subscribed to the securities. Either you're switching, or if you're agreeing to subscribe, redeem, switch, buy, sell, or deal in the securities, it would be considered that trading has been done. Because the trading would be done on the basis of those agreement to do so. So the key components here when the trading comes as like, if any person is applying in the IPO, FPO, rights issue while having possession of UPSI, is considered as a trading because it is they are not really getting doing the trade at that moment, but subscribing to those while in possession of UPSI is a trading. I mean, it is always a trading. I mean, but the person is in possession of UPSI, then it becomes a reason to of a problem sometimes. Any buying or selling of and the secondary market transactions, both on the exchange or of the market, would be considered as a trading. If there are any OTC deals or the block deals, bulk deals, everything is covered under the definition of trading. In fact, if there isn't any agreement to do the transaction of these buying, sell, subscribe, or deal, where the transaction in reality does not happen at that moment, that would also be considered as a trading. So, along with the trading, there is another definition which has been mentioned, or a terminology which has been used in the regulation is considered as a trading plan. So, the trading.
Sakshi, 1 minute before you switch over to trading plan,
Yeah.
you see the definition of trading. It says that trading means and includes. This is an inclusive definition. It says subscribing, redeeming, switching, buying, selling. We know all this terminology now. Dealing. What is dealing? It is not defined as such. Or agreeing to subscribe, redeem, switch, buy, sell, deal, or any of the securities, and trade shall be construed accordingly. So primarily to understand here, as far as the other things are concerned, buying, selling, subscribing, redeeming, switching, buy, sell, blah, 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 and all, there is an exchange of consideration is involved in this. But if you see kind of dealing, what is dealing means what? Dealing means a pledge of securities. Pledging, you are doing it, that is kind of dealing. Transmission of securities. Gifting of securities. Suppose you are giving a gift of the shares of the company to your relatives or anybody like that. It is also a part of trading only. So you have to be very clear that understanding the definition of trading is very important, because contra trade, when we discuss, contra trade means it is a trading has taken place. So if you pledge it, can you depledge that within 6 months? Is it going to be affecting the contra entry or not? If you see the SEBI FAQs, there are a lot of FAQs are there on the trading act definition itself. This is one of the important definitions for the purpose of determining what is a contra trade, whether the designated person can enter into the contra trade or not. Yeah. Sakshi, go ahead with the trading plan.
Sudhakar, someone has asked what is switching. Can you explain?
What is
Switching.
switching? Yeah, switching means, say, for example, I have pledged that, suppose my shares with one bank, and I have taken loan with an X amount of interest, and now I want to switch that particular pledge to another bank. So I will depledge that, and again I will repledge it, because where I am getting the lower rate of interest. But the problem with this thing is whether it is going to affect, it is going to be a contra trade or not. That is need to be seen. So switching is that basically.
And someone has asked, locking is dealing, like promoters locking in IPO is also dealing.
No, promoters lock-in is a different thing. See, that you are not doing anything. It is simply you are locking the shares. Where is the question of dealing? Dealing or anything means what? You are entering into a transaction with somebody. So dealing, as I mentioned to you, your any kind of activity which is not, you are not exchanging consideration for that, they all will come under the dealing. As I mentioned, pledging of activity, gifting of securities, transmission of securities, these primarily will come under the dealing.
They have
we can
asked whether
see we can see that dealing, we can say that credit and debit is there. Whenever there is credit or debit, then we can say that it's a dealing, means debit
Correct.
and credit should be there. And second thing, SEBI has beautifully explained the concept of trading with respect to ESOPs in its FAQ. So I will request all the audience to please go through that. They have beautifully given the table in tabular form. They have beautifully explained this concept of ESOPs.
That is the purpose of the contra trade. Yeah.
In fact, I would say pledging has been included in the trading, which was not earlier, but SEBI has mentioned that pledging would be considered as trading. So now we will discuss about the trading plan. So trading plan is a plan which has been submitted by the DP to the compliance officer. So basically, that plan tells in advance about like how they are planning to buy or sell the securities of the organization well in advance. And it allows the insiders to pre-schedule trades in advance, which provides a safe harbor against the PIT liability. So, but there are certain requirements with respect to the trading plan, that it needs to be approved by the compliance officer, that needs to be disclosed to the stock exchange before it comes into force, and minimum 120 days period between the formulation of the plan and the first trade has to be there. And the plan needs to specify in advance only the date of transaction, the future date, price, and the quantity, or if there has been any formula which has been made by that particular person for dealing in those securities. Once the plan has been approved by the compliance officer, it cannot be modified or cancelled except if there is any exigent circumstances. And yes, trading window is not applicable on the trading plan. But it becomes, I would say, there are a lot of practical issues with respect to trading plans, and it has not been used by many insiders since the compliance burden is quite high under this.
Sakshi, I would like to here I would like to add that with respect to trading plan, the SEBI has made it a little friendly by reducing this minimum time period of 6 months to 120 days. To since there were not many takers for this trading plan, and further, earlier the trading plan, once it has been means disclosed, it can't be revoked. But now they have given this flexibility that if the plan cannot be implemented out of incapacity, bankruptcy, operation of law, or suppose there is illiquidity in market, or now trading plan also can give the limits with respect to the maximum limit and lower limit with respect to buying or selling. So if these conditions are there and the trading plan cannot be executed, so from the compliance perspective, the insider has to give the reason to the compliance officer along with the details that why this trading plan cannot be executed. Compliance officer in turn has to go through the reason, and along with his recommendation, it has to be placed before the audit committee. This is the reason why trading plan was not executed, and the decision of the audit committee need to be disclosed to the stock exchange the very next day. And if there was not bona fide reason why trading plan was not executed, then in that case the it has to proceed according to the code of conduct. Yes, Sakshi.
Yeah. But anyway, that what we will do is that trading plan we will not discuss much in this webinar because we are
Yes,
going
yes,
to
yes.
discuss the definitions
Understand.
and key terminology. But in the next webinar where we will have a full-fledged trading plan segment, that time we will discuss all the related details.
Sure.
Okay. Yeah, Sakshi, go ahead.
So the other key definitions under Regulation 2 includes Board of Directors, which we all know that it has been defined under Companies Act, and it includes all nominee, independent directors, additional directors, and persons occupying the position as a director on the board. Then the listed securities of the securities of the listed company as defined under SCRA, which includes equity shares, convertible instruments, derivative based on such securities. And the securities is defined again under SCRA. It includes shares, debentures, bonds, units, instruments, derivatives, and right interest in securities. It's a very wide definition. So the only purpose of adding these definition over here is that the securities are not only limited to equity shares. Security here refers to all convertible instruments, derivatives. You say that we say a lot of times, the debentures, bonds, units, and if any FNO transactions which has been made, futures and options trades which has been made, which is not a direct dealing in the securities, is also considered under as a security and would be considered as a part of trading. So the only purpose to understand here is any derivatives on the underlying UPSI affected securities are covered, which is inclusive of FNO trades by insiders, which will always trigger PIT. So now we will be discussing about the other key terminologies which has not been defined under Regulation 2 as the definition, but are very important to understand for moving ahead with these regulations. One is legitimate purpose. So legitimate purpose has been used at numerous places in the regulations wherein it has already been mentioned that if the information has been or the UPSI has been shared for the legitimate purpose. So now what legitimate purpose is? It includes sharing of UPSI in the ordinary course of business by an insider with partner, collaborator, lender. It could be anybody. I mean, connected person, not connected person, merchant bankers, legal advisors, insolvency professionals, or any other consultants. However, that sharing is not being carried out to evade or circumvent the prohibitions of these regulations. That needs to be the purpose of sharing those information. I mean, there has to be a specific reason if the company is making the financials for the financials is being getting finalized. That needs to be shared with the auditors for making their audit report before its approval. with the board. So that is a legitimate purpose for which the particular insider or the DP is sharing the UPSI with the other advisors or the audit professionals. So that's how the legitimate purpose and needs to be identified wherever any UPSI has been shared. And then the other definition or the term comes as the communication of UPSI, which is quite related to this. So no insider shall communicate, provide, or allow access to UPSI to any person except where such communication is furtherance of a legitimate purpose, performance of duties, or discharge of legal obligations. So these are quite interrelated in a way that the first we have to understand the if the information is if any UPSI has been communicated to any other person, and if that has been done so, what is the purpose of that same? That purpose needs to be a legitimate purpose. And as there is a principle of need to know basis, if sharing of information within the organization is also restricted without any legitimate purpose, legitimate business need, if the person is required to, the other person is required to know that particular UPSI, then only it needs to be shared with that other person. Now the other terminology comes here is the designated persons, that is we refer as DPs. We have also referred these as at many places earlier in our presentation as well. So this includes the board of directors or any other authority. In consultation with the compliance officer, they are required to specify the designated persons to be covered by the code of conduct basis their role and function in the organization, and is assumed that they have access to the role and function would provide to unpublished price sensitive information in addition to their seniority and professional designation. And DP shall include employees of the listed company, intermediary or fiduciary designated on the basis of their functional role or access to UPSI in the organization by their board of directors or analogous body. So the board is required to identify the DPs on the basis, like if any employee, on the basis of their either role or the seniority, how they, if they are having any access to the UPSI. And it is not only restricted to that complete particular organization. Employees of the intermediary or fiduciary would also be inclusive of that. In fact, the employees of the material subsidiary of that particular listed company is also required to be designated. The listed companies and the promoters who are individual or investment companies for intermediaries or fiduciaries would always be considered as DP. Any support staff from the listed company, including intermediary, fiduciary, such as IT staff, secretarial staff who has access to the UPSI information would also be considered as the DP. So DP, when it comes to DP, the board of directors are required to identify them. So as it has been mentioned, two levels below the CEO has always been considered as a DP along with the promoters and the board of directors. So the other support staff here becomes like, it becomes a liability on those. Maybe we can say the head of those departments are required to identify if their department is having access to UPSI and that particular employee of that particular department would be dealing in that UPSI would be considered as a part of the DP. Generally, secretarial team, compliance team, the finance team who is working on the financial statements are always being part of the DPs. In fact, the secretary to the MD office is also considered as a DP because the secretary would be having access to the whole system of the MD or the directors. So that is also considered as a DP in the organizations. And it is very important for the company to clearly identify and define who they would be considering as a DP. because it would be the better the way it has been explained, the compliance would be better at the organization, because it after a certain thing, some people as the DPs, lot of compliance is are required to be done by them. You want to discuss on this, or should I just go ahead?
Then go ahead. We will discuss it when we are discussing about the codes in detail about that. Okay.
Perfectly fine, sir. Then there is a term which has been used in the regulation, which is structured digital database. So here we'll just understand that it is required by every listed companies to maintain a structured digital database internally, which will capture the name of the person with whom the UPSI is shared, which includes their PAN details and the identifiers and the natures of the UPSI. This database is required to be maintained in the organization, and the time stamping is very important. As sir has mentioned earlier as well, the SDD is required only for the purpose of the or maintaining the audit trail, which is not required to be tampered with. If anything happens later in the organization, the SDD data will be taken out and will be checked if that person has made a proper entry in the SDD that they were having access to the UPSI. And
Sakshi, another thing is there, the SDD is actually a real-time entry, because
Yeah.
the whole idea, as you rightly say, is the audit trail. When, what, whom, when the information shared, and all those things to establish that is how it is required. So if the people are asking if the SDD can be entered later, after the event, etc., and all this thing, nothing, it's all the violations. It has to be on the real-time basis. Yeah.
Yeah, but in for the information which is generating from outside the organization, it needs to be entered within 2 calendar days of receipt of those information. Some relaxation has been given under 2025 amendment, and it is, as we have discussed, that so it is the single most decisive piece of evidence in the SEBI investigation to establish and to review the allegation of the UPSI communication. So, at the later stages, when we will be discussing in the other sessions or the SDDs in detail, it is quite an important evidence to actually understand if any insider trading has been done or not. Now we have a lot of times during our presentation as well, we have discussed about the intermediary.
It is actually a lot of questions are there, and our time is very limited. So this wherever it is this thing general, you can just skip off those things. SDD we will discuss again. A separate webinar is there on this. Go ahead for the.
This is the last definition.
Okay.
Yeah, I'll wrap up fast. So intermediary has not been defined under these regulations, but it has been defined under Section 12 of SEBI Act 1992. So any stockbroker, broker, share transfer agent, banker to an issue, trustee, trust deed, registrar to an issue, merchant banker, underwriter, portfolio manager, investment advisor, or any other intermediary associated with the security market uh, are considered as an intermediary who are registered with the SEBI. So, and there are two terms which has been used synonymously in these regulation. One is intermediary, other is a fiduciary. So fiduciary includes the professional firms as auditors, accountancy firms, law firms, analysts, consultants, banks, valuation agencies, fund accountants, AMCs, trustees, registrars and transfer agents, custodians, CRAs, and just to by adding these two definitions here, we want to understand that the ambit of this insider trading regulation is not only limited to the listed company, but to these intermediaries and fiduciaries as well, wherein, like we have discussed in the definition of UPSI, the employees, the partners of the intermediary or fiduciary. So every organization needs to clearly identify the intermediaries and the fiduciaries they are dealing with. So there are certain practical challenges while we apply the definitions. To understand the connected person post resignation, we have discussed that the 6 months time period is very important, and it is important, and it is, I would say, a liability to track those connected person for the 6 months. So we have already discussed this. Then the other one is identifying UPSI versus materiality threshold, as we have discussed. Like UPSI's indicative list has already been given, but the materiality threshold has also been considered as per the SEBI LODR, and then accordingly needs to decide if certain information which has not been mentioned in the definition of UPSI, however, it is breaching the materiality threshold, it becomes a UPSI for that organization. UPSI is not related does not confine till in the territory of India only, as we have discussed. If it has been discussed out of, I mean, out of India as well, it would be still considered as a UPSI. For example, a portfolio investors and a FPI fund manager, which is based out of Singapore, receives a UPSI from an Indian company. So PIT has an extraterritorial application, and those FPI can be investigated for those insider trading in India. Digital channels and a UPI leakage. Employees, if they shares undisclosed acquisition plan on WhatsApp group, it is not mandatory if they write it an email and then share those information. If it has been discussed through the informal channels as well, it has been inclusive and would be considered as an evidences. Then the ESOP exercise during UPSI period. Employees who exercise UPSI during trading window closures before the quarterly results, it is considered as trading while in possession of UPSI. But I guess contra trade is not applicable on the ESOPs. There has been a lot of FAQs about the ESOPs by SEBI. So we have discussed, like at the later stages, we will be discussing the penalties provisions in details, but to understand the penalties are quite high in the SEBI PIT regulations, because the penalties has been mentioned under the SEBI Act. Minimum is 10 lakh, which goes up to 25 crore or 3 times of the profit, whichever is higher. And unlawful gains which has been made needs to be disgorged. Even penalties have imposed. So there are the two ways the person needs to actually pay the penalty. And there could be imprisonment as well up to 10 years, and there would be a fine. And other than these penalties in the monetary and non-monetary forms, the person doing insider trading can be barred from the security markets as well, whether temporarily or permanent. And there have been many cases. Only 4 has been listed out here, but I would say in a day-to-day basis, there have been lots and lots of cases on the insider trading. And the case of SEBI versus Chetan Mehta, as we have seen, informal channels would also be considered as evidence under these regulations. So they've used WhatsApp chats as an evidence because the merger deal UPSI was shared informally. So there was a 28 crore disgorgement of amount. Then in the case of Reliance Industries of 2017, the futures were traded ahead of the stake sale. SEBI held that it is a front running with insider information. Derivatives, as we have discussed, derivatives are also covered under trading. So FNO route is not also been escaped here. Then in the case of a Syncom Healthcare, promoted traded ahead of adverse financial results. So the promoter was debarred and 5 crore penalty was imposed. So it's not like UPSI on a higher side. Even the negative UPSI, if the results are going to be bad, if the shares are going to fall after that particular UPSI becomes a generally available information, that also triggers restriction. Any sort of trade, whether it's good or bad, needs to be considered as a trade. Nobody can short sell either. It would be considered as a trading. In the case of Wipro Insider's case, multiple connected persons traded before the quarterly results. Tipper and tippy chain was established, and tipping carries some liabilities as a direct trading. Connected person need not to trade by themselves, but if the transactions or the trading has been done through a chain system, that would also be considered as a trading under these regulations. And thank you about that. Now we will take the questions.
Okay, let me run through the question from
I'll
the
stop
beginning.
sharing.
Yeah. So Bala, you please take the questions only pertaining to this webinar only. because we
Okay.
are going to discuss structural digital database transactions, all other things as and when that webinar comes, okay? Because there are a lot of
Okay.
questions about those things also. We are not going to discuss, only confine the questions to today's webinar only.
Sudhakar, first of all, you accept a lot of happy wishes to you people have expressed
Yeah.
here.
Thank you
So
very much to everyone. Thank you.
that is actually the starting point actually. There is somebody has put a question. NGO सेबी के साथ कैसे work कर सकते हैं? Any idea?
No, it is not relevant, Mr. Bala.
Nothing
Next.
to do with it.
Nothing to do with it, but only thing is the NGO wants they can go to that what do you call the stock exchange on which they wanted to get listed and other thing and not profit purpose. That's the only thing. Nothing else in there. Either a comprehensive list of the what would be a UPSI. I think you discussed, you elaborately said it very clearly on this. Does a PTI regulation only apply to the equity listed or debt listed company also? If company NSE, BSC, if it is PTI is applicable, it is applicable for all the securities. That is what she explained. Debt listed company, NCD, everything, any security, it covers all the securities. That is the thing. Can there be a two compliance officer at the same time just to make an operation smooth as CS and other who's having a knowledge of the trade? Yes, you can have as many as compliance officer you want. In fact, larger companies, it is actually possible. So it is possible you can have it. PTA is applied to all this. Yeah, okay. I'm outsider, not a connected person, who while on the business visit to the office of the company, hear some information spoken by the senior management. I based on that information execute trade in the company stocks. Will he be held as an insider?
Certainly, he is an insider.
Yes, answer is yes. Yes, actually. In fact, I remember Sudhakar sometime back. I think I don't remember exactly. You said actually somebody went for a haircut. He was sitting in the barber shop. He was discussing certain issues. They heard it. They traded it. That's what you said actually.
See,
Something
not
like
only
that.
that, not only that. See, several times what happens is your friends or the friends of your other colleagues may come sit in your cabin for hours together. During that time, you might be receiving phone calls, you might be instructing your subordinates or receiving instructions from your superiors. With all these things, if a person is regularly visiting you, he can certainly have the access to the UPSI also. That's why big companies never allow the visitors to the cabins of the senior officials. When I was working for Reliance, we have a strict no as far as the visitors to their cabins are concerned. You have meeting rooms are there, please go and meet that. In fact, I have seen that same procedure in several major companies also. Better to have that, never ever allow the visitors inside your what's called a working premises. Have meeting rooms, meet them there only, and then see them off from there only. That is always
Absolutely.
advisable.
Absolutely, you are right, Sudhakar. In fact, in the reception itself, we have kept a separate meeting room. Whenever the
Correct.
people come, the receptionist will give a call. The person has to come down. He has to sit there. He has to meet and finish all. He is not even allowed to enter inside beyond that reception area. That is what we had actually. Insider regulation is applicable for delisted company. That is the question. For example, my understanding is that UPSI is applicable to listed company. However, it official received OTS proposal from the delisted company. Then insider regulation is applicable. That is the question. I think according to me, if the company is under delisting, it is applicable. Even after the delisting, if the shares are traded, even the off market, I think it is applicable. What do you say, Sudhakar?
See, if a company is delisted, it is no more a listed company, then obviously SEBI regulations are not applicable to that company. So where is the question of SEBI regulation applicability to a delisted company?
Next thing.
See, till the time it is
Okay.
not delisted, okay, in the process of delisting, that is a different thing. The moment you receive that letter that yes, your shares are delisted now onwards, from that day, applicability of insider trading regulations will not be there.
If ABC company engages with a third-party service provider to assist with applying for a license, should that service provider be included in the structural database or should they be treated as an insider?
He will be treated as an insider.
Okay, because she has already answered. Depends upon the UPSA shared with him by the company yesterday only to be made. That's what she said actually. Give
See,
citation of
please
the
remember that SDD entries are to be made only for the designated employees. Because for insiders or connected persons, as I mentioned earlier, the companies are not responsible to regulate those trades. Only designated persons are concerned. You have to make the entries in the STD.
Shashi Sharma is putting attended CS webinar. I am in a various CSR committee. Can somebody from Mehta and Mehta contact me on my numbers also or give me some mobile? My office will connect. That's a request which is he has made, I think so. I think Dolly has already answered. Sure. What is the reporting requirement of the SEBI regarding all connected person? Otherwise, what is the methodology for overseeing this aspect by SEBI? I think this is going to be discussed in future on the reporting requirement. I think we will not take this question just now. Can you explain the connected person with the example? I think is already discussed here. Can SDD entry be made in the software after the event is over? Obviously, no, it is a real-time entry. That is what we have been discussing it actually. Please correct me if I am wrong. UPSI is applicable only on listed company. If I am right, how UPSI applicable delisted company? Yeah, Sudhakar answered it just now. How does the company know about the transaction in its share which are done without seeking registered transfer or only F&O?
See, actually, see that all the designated persons, in fact, they are prohibited to get into the F&O transactions. If anybody is doing the F&O transactions, of course, obviously, company will not come to know about that. Then SEBI will take care of that.
How SEBI will track that person have traded on the basis of the UPSI and the same person sharing common resident with the connected person? How SEBI will track such an activity?
Surveillance is there. They have very strong surveillance department. So exchanges are having a very strong surveillance department. So. And
Sir,
they are
as you
under
said,
obligation to inform SEBI. See how it happens normally. Stock exchanges through their surveillance departments keep a surveillance on the companies whose securities are being getting volatility in the trading is there. The moment it is going upside or downside means somebody is playing in the market. That is the trigger point. After that, they will be started watching, and as and when they got any kind of indication that there is some kind of nefarious activities are taking place, then the necessary investigation will be there and will be intimated to SEBI accordingly. Then SEBI will obviously get into the action.
sir, as you said, onus is on the person who made the allegation. But in case of the connected person, onus is on the connected person to prove that he or she has done, he has done or not done with the UPSI. No, you're right actually, because the onus is always it is like that
See,
only.
as I mentioned, that onus is on the connected person means that SEBI will say that, look, you are a connected person because the definition of connected person is there, the people who are deemed to be connected persons. So as I have mentioned earlier, it is it is the responsibility of those persons to rebut that yes, they are not indulged in the insider trading activities, or at the time when they have done the trading, they are not in possession of that UPSI. They should be able to establish that, get away with that allegation.
Most brokerages have a hall with a TV broadcasting share market, where they encourage clients to attend and get the inputs for the trading. In such a situation, if the brokerage is connected person, then all the clients attending and seeking brokers' advice in trading become a connected person. How do you actually deal with this situation?
See how the broker, see the broker is not a connected person, because he is not, I mean, you are not supposed to share any kind of information with the brokers. Okay, so how you can say my broker is a connected person?
Generally available.
Your banker may be a connected person because you are under obligation to share certain information with your banker, but not with your broker. And company can never engage brokers.
Generally available necessarily means disclosure to the stock exchange. I'm not getting
Yeah,
the question.
generally available means which is available in the public domain to everybody and anybody without any cost.
How can we quantify the price sensitivity? Can a company define percentage of the price sensitivity by its own, or can based on the MRV limit, example 3%?
See, it is definition is there already. It says that material impact on the share price. That is how it is to be seen.
Approval to make an application to the key license will qualify UPSI. Approval to make an application
It depends,
for key
by merely
license.
making an application is not an UPSI, but getting that license may be an UPSI. You cannot say it depend upon case to case basis.
Yeah, because suppose you start new business which require a license and that you decide, then it is so case to case.
In the event of the change in the key managerial person, such the appointment of the resignation of the company secretary, managing director, chief financial officer, which constitutes unpublished price sensitive information, is the company mandatorily required to close the trading window? If so, from what date should the trading window be closed, and until what date should the resolution remain in force?
See, trading window closure is two types. One is that financial results, that is, you are closing the trading window across the organization. That means all the designated persons are not supposed to trade in the shares of the company during that window closure period. That, of course, you are under obligation to intimate to the exchanges about the trading window closure. As far as other things are concerned, it is not across the organization. So you are not going to close the trading window for everybody and anybody. It will be closed only for those respective people who are not. That means you will be intimating to them that, look, this is a window closure period as far as you are concerned. You are not supposed to trade in the shares of the company till such time you have been again intimated on this. That is what the window closure is concerned. Selective
What is the
window
meaning?
closure need not be intimated to the exchanges.
What is the meaning of materiality here? I think you discussed that actually. A contract which is entered in the normal course of the business, but terminated by the other party due to the possession of the UPSI, will such termination considered valid or not?
Yes, termination of a contract is also an option.
If requests arrange one webinar or how to make and trigger time, conclusion time, intimation, trading window closure to person and disparity, etc. Yes, it is going to be discussed because it is a series of the webinar which is going to be done. Please wait for the future seminar. It will be actually coming actually. Do we need to give the intimation to the stock exchange if we want to close the trading window for selected designated person due to sharing of the UPSI with those person? Just those Sudhakar explained actually, not required. It is only the person connected should be intimated. Okay. Do we need to close the trading window for that person in NSDL, CDSL every time we record an STD entry?
Not required.
My management suggesting keep the trading window closed permanently for designated person to avoid trading. Is it possible?
No,
I think
permanently
she
you are
answered.
not closing the trading window, that's not required. It is like that. You have to close it only, as I mentioned to you, on quarterly basis for financial results. That point of time, you have to intimate the exchanges.
Does trading include creation of the pledge? I think pledge is now covered. That's what she presented during the course of the presentation. Can you please explain the concept of trading window close? What happens during such period and it's applicable only to connected person and immediate relatives?
See, trading window closure, it is only a notional window closure means during that period, the designated persons or their immediate relatives are not supposed to trade in the securities of the company. It is not like that you have a window or you are physically closing it. It's not like that. But only thing is a communication has to go from the compliance officer across all the designated persons stating that the purpose of the trading window closure and from how many days you are going to close it. Normally, as per the listing regulations, what we have to do is that we have to close the trading window from the first of the subsequent quarter till the time the results, the board considered the results and published the same. 48 hours after that, you can open that window.
Yeah,
Maybe
you're
1st
absolutely
April
right.
or your 1st July, 1st October, and your
Yeah,
1st January, are the dates which starts with.
Yeah, you're right. Actually, Sudhakar, what happens is normally we create a group of the designated people separately. What we do is we send out a mail to all the people. The period, the trading window closure will commence from this date until end this place. During this period, you are not supposed to deal on this matter, etc. And also, that is a normal circular which is actually sent over. That is a methodology practice. Practicing it is working actually.
Sorry,
Okay,
Hema, I think I'm answering all your questions. Actually, you are the expert panelist and you have to answer. Now onwards, you answer the questions. I'm sorry, but I am answering all the questions.
what is
Follow
switching?
close to Hema now.
What is switching?
I think Sudhakar sir explained this, na? Switching portion.
Next.
Okay. Whether investing in a mutual fund, SIPs, or where the company security may be one of the component is covered under the UPSA.
Yeah, we are going to discuss this also in a separate webinar about applicability to the mutual fund companies and all. We will discuss at that time.
Okay. Pledging innovation, again the same question. Switching is again the same question. Locking is a dealing.
No, that Sudhakar said explain. It's
He
not.
answered this. Yeah.
Okay. Promoter locking in IPO is also a dealing. That is the question actually.
That we answered.
Can dealing mean a set up combination of the transaction which includes buying, selling, etc., and also forward trading or shortlisting or derivative trading? That's what one of the participants has actually put here.
Is buying selling is given separately, and dealing means this it will include forward trading, derivatives.
Now suppose banker to my company is holding the share in my company to whom I am sharing some information on a monthly or quarterly basis. Now we also added banker as a connected person. Now the question is, do I need to close the trading window for them?
A trading window is not closed for the connected persons. Actually, it's for the designated person. We are closing the trading window, but however, we can ask the connected person to state the holding in case we are selling UPSI with them, and ask them to intimate us their holdings. A trading window is closed for designated persons.
Trading
all
plan should not.
all the intermediaries are supposed to have a separate code of conduct.
Yeah,
Like
they will
your
have
auditors, secretarial auditors, your bankers, financial institutions, every one of them have to have a separate code of conduct. And they have to identify the designated persons. They also have to comply with that. I think, okay, that part C of the insider trading regulations as having a model code of conduct for the intermediaries of the companies.
Yes.
So all the
Trading.
practicing company secretary forms, if you are having any kind of secretarial audits of listed companies, you are supposed to maintain this what's called a code of conduct for your firm as such. Whether it is a chartered accountancy firm or a secretarial audit firm or whichever it is and all, you have to have that. Yeah.
Trading plan should not overlap. This overlapping of the cooling period is the execution period is one of the.
We will discuss the trading plan when it comes, Bala.
Okay. What happens, the pledging of the security generally and the way that is done in the company, it's a pledging, borrowing by company with a bank. So in the case of the default of the borrowing, bank will invoke the pledge to satisfy a default amount. Hope my understanding is correct.
This is pledging, it's okay. And it is understanding is correct invocation.
Okay. Meaning trading plan once approved must be implemented and cannot be cancelled is the question.
Trading plan issues we will discuss separately.
Okay. Again, next is actually the trading plan only. So that we won't take here. Next is actually trading plan. Okay, trading plan. Again, trading plan only, it is a question coming. What is the pre-clearance and how much value quantity ideally can be set by the management?
This also we will discuss in the future webinars.
Okay. Can a person be held liable for insider trading even if they did not personally profit from the trade?
I think Hema has answered this question, and the profit is not material. You have breached the trading regulations or not, that is more important. Whether you made a profit or not, that is not material.
Is it mandatory to close the trading window for all the insiders who hold to UPSA and listed down in STD? Is there any duration for which any information remain in UPSA?
Until it's made public, up to 48 hours, this trading window will open.
Can a person in possession of the UPSA trade at the mutual fund? That you said we are going to discuss later. Kindly explain PIT regulation from AMC standpoint.
Same thing when we discuss with mutual funds, that time we will discuss this.
Okay. Level can be grade or it needs to be reporting level.
It's seniority with respect to CO and 2 level.
If the ex-employee after 8 months of any trader, seller or purchaser raw material person traded during TWC, then what will be the impact and what are the things to be taken care of? Trader is currently doing the transaction with the company. We cannot prevent him to purchase from the open market. So how company should take care of such things in case of any clarification comes. Many times want, but they still trade during the trading window. But he used to do it.
He is only a connected person. He is not a designated person. So it is not the responsibility of the company to regulate the trades.
Okay. Anyway, next question relating to mutual fund and SIP and all that we are going to cover later. With the HR officials, the IT department fall under the designated person category?
No.
Okay. What is the frequency to submit SDD return to SEBI, if any?
We will discuss in future webinars.
Okay, again, can there be a 2 compliance officer that we actually discussed this? Can PAN be freeze for the UPSA other than the financial results?
Not required.
NST is only, sir, giving freezing option for quarterly results currently.
Correct.
Exercise of ESOP or exception to the trading window closure, then why the employees can exercise?
Again, we will discuss this, Bala, in the future webinar because ESOPs separately, we are going to have a session on that.
Okay. Can responsibility of CIRO comply by CS or any other senior officer, or can compliant officer can perform the functions of CIRO?
So it depends what whose name has been given in code of fair disclosure.
Okay. Next question is pre-clearance that we are going to discuss later. If a person who is a perpetual possessor of the UPSI information, example CFO and the trading plan is not prepared by the CFO, can the CFO make on market purchase of the share of the company whenever the trading window is open?
No.
See, basically the people who are having perpetual OPSI with them, for them only trading plan is there. So when we discuss trading plan in the next webinar, that point of time, we will discuss it in detail.
If a DP has not furnished timely disclosure regarding the trading in share of the company, can company penalize it?
What is DP?
Next question is relating to mutual fund that we will speak later. If the company opens for IPO, from when PAT applicable to me?
See,
Sir,
normally it is 6 months before, I think, right? FEMA, if I'm not wrong, 6 months before.
Sir, the soon they have filed this DHRP, then or if it's a case of merger, then they have filed a scheme with the ROC. It will start from that time onwards. This regulation will be applicable.
Is PAT regulation applicable to the unlisted asset management company?
Unlisted.
Unlisted companies, it is not applicable.
The disclosure requirement of the PAN related, immediately related, or financial dependent, other disclosure of the PAN not required. How to trading freeze the depository for those related with the disclosed by the designated person?
Disclosure requirement. Nowadays, sir, we have to furnish the PAN of all relatives, means
Yeah,
all
correct.
immediate relatives with the NSTL CDSL portal.
Yes.
So it will
No,
automatically get
he
freezed.
say disclosure requirement is to immediate relative and not all the relatives. So how can I create? That's a question, I think so.
See,
So other
because designated person, I think all relatives is not required. Now only immediate relatives responsibility is there.
Yes.
Okay. PAT applicable to the unlisted subsidiary of a listed company?
Material subsidiary.
PAT regulation applicable to unlisted asset management company, that you said if it is unlisted, it is not applicable. Okay.
The one minute, see, PAT is not also applicable to unlisted material subsidiary. Only thing is, if any happenings are there in that material subsidiary, I mean unlisted subsidiary, which is having an impact on the share price of the listed company, then that information is also to be considered as upside.
Do I need to take disclosure from the banker to company for pledge of creation by the banker?
Do I need to take this?
Also, do I need to take disclosure from banker to company? See that I couldn't understand this question. What is exactly it says?
Okay, when you there, we'll ask it.
Yeah.
Kenan, you can put it what exactly you mean here in this question. We are not able to make it out. Okay. Could you please explain why SDD entry is not mandatory for insider?
We will discuss this.
Okay. Is sharing of the financial of the company to XPRL vendor also a sharing of UPSI?
See, by that time, this information will be published in the market here.
Okay.
By the time
Regulation,
it goes to the printer or XBRL, it is already published.
Regulation 3.5 specifically say the board of director, heads of the organization, or every person required to handle UPSI shall ensure that a secure digital reserve maintained containing nature and purpose includes such a person with whom information is shared under this directory along with the
SDD, we
permanent
will
account.
discuss it now. SDD anyway, leave it.
Okay. Can a person who was penalized by the SEBI on insider trading be made a MD or CEO?
I think there is no bar in the Companies Act. Only you have to see that Schedule 13, Schedule 5, Part A, you have to say that 18 qualifications which are there. If he is fined for 1,000 rupees and above, he cannot be appointed without central government approval. That you have to say that.
Intermediary is a connected person.
Of course.
Okay. Whether the statutory auditor or other auditor to be considered as the DP, as a DP or connected person, whether company needs to define somewhere to establish their position under AIT?
They are connected persons, sir.
Is closing trading window by a company listed with the Calcutta Stock Exchange is required? But where is the Calcutta Stock Exchange? Calcutta Stock Exchange and other things are all, now it is not there. It is only a two nationwide trading exchanges only. All those concepts has already gone, I think. Am I not correct by understanding?
Yeah, absolutely.
Sudhakar?
Yes,
because I don't know why this question Calcutta Stock Exchange. I don't think any regional stock exchanges are now in existing.
No.
Okay. Is it meaning a forward sell purchase may be entered into a connected person based on the insider information? Actual execution of the transaction may take place up post reopening of the trading window?
Connected person has nothing to do with the trading window.
Which employees are considered as a designated person as per functions? I think she actually explained initially elaborately on the connected person. As a secretarial auditor, how do I ensure that the company update detail of designated person detailed in the designated depository? As a secretarial auditor, how do I ensure that company update detail of the designated person detail in the designated deposit?
Hema, batao.
Sir, they are taking certificate from us, secretarial auditor, though they are not taking the entire list of designated person, but they are taking confirmation from us that we have updated the list, since they have to mention this in annual secretarial compliance report.
See,
Sir, as you write,
it is the responsibility of the company to identify the designated persons. That the designated person's identification, it has to happen through, as per the code of conduct, right? And then once it is there, suppose as a secretarial auditor, you may take a list of that designated person certified by the compliance officer. And whether they are uploaded on the designated depository or not, that, obviously, again, the same thing that you have to see that whether they have done it or not, the compliance officer has to show the process and what they have adopted. That's how you have to do the audit.
Sir, as you rightly mentioned, not every UPSI is required to be disclosed to the stock exchange. In such a cases, it may be sufficient for the company to impose trading restriction on designated person. However, if any unusual event subsequently occurs and SEBI questions the company's decision not to make disclosure, how can the company justify that the information was not required to be intimated to the stock exchange?
See, Regulation 30 is different to that of UPSI. Regulation 30, you have to intimate to the exchanges. UPSI is concerned, you don't need to intimate the exchanges as such. Regulation 30 is much more than UPSI, because there are several things are there in that Part A and Part B of what's called the Schedule 3. So it is much beyond that UPSI. UPSI, you don't need to intimate to the exchanges. Only Schedule 3 you have to do that. Regulation 30.
Or small insignificant buying, selling also included in the debarred transaction?
If UPSI is there, even one share sale will be coming under that debarred transaction.
Okay, where should be the SDD server? I think that we are going to discuss later, I think so. That is the thing. In company or third party, yeah, that we will discuss later. With that, I think. Can a trading be done by the insider as per the trading plan during the closure of the trading window?
Yes.
Once you say, yeah. Here, sharing of the financial company XPRL that you already answered actually. Server, where should I SDD server install that we are going to talk? Plan freezing also we discuss. I think I am done with all the questions here. Nothing is left out now in the chat box. Let me see, any hand is risen. Yeah, there is one hand is actually risen by Shivam Sharma. Can you unmute and speak, Shivam Sharma? Are you there?
I think by mistake it is. It seems long.
I see. Because I
Yeah.
can see one hand actually Shivam. If he's not
If
there,
anyone
then I.
wants to speak, raise the hand. Otherwise,
Yeah.
we'll close the session. Yeah. Mr.
Yeah.
Ravindranath Reddy, unmute and you can speak. Mr. Reddy.
Yeah.
Yes,
Good
Raghunandan.
afternoon. This is AGR Reddy. See, I have one question to Mr. Sudhakar. See, I have seen many SEBI adjudicating orders where the penalties are not incommensurate with the profits made by the insider. So, what's your comment on that?
See, not necessarily, okay, that your penalty is concerned, it has to be coincide with this thing, though it should be actually as such, but it all depends upon the presiding officer, okay, that what sort of breach has taken place, under what circumstances it has taken place. Suppose you might not have profited with the transaction, but you might have made others to incur a loss on those transactions, So it all depends upon case-to-case basis,
Okay.
And in case if you feel like that, if you have a grievance, and you can always go to SAT.
Thank you.
Yeah.
Can you please explain disgorgement? Somebody is asking a question. Krishnan is asking.
Disgorgement. See, disgorgement is nothing but if a person has made any kind of profits, with this insider trading activity, that point of time, the SEBI may order that to disgorge the profits, whatever they have made. In addition to that, they can impose penalty also. 3 times the profit made, up to that is the maximum penalty what they can impose. So that means, suppose if I made an insider trading regulations breach and I made a profit of about say 10 crore rupees, that 10 crores they will disgorge. That means they will ask me to deposit that money. Over and above that, they may also penalize me for that.
Sarita is just giving information for you on the Calcutta Stock Exchange, saying that West Bengal planning to support the Calcutta Stock Exchange revival in the state budget 26-27. That's it.
Mr.
That's all. Nothing
No.
else is there. With that, we come to the end of the discussion. Last word from Dipti.
Yeah. Thanks, everyone. Thanks, Miss Hema, for your time on
Thanks,
Saturday.
ma'am, for inviting. Really, ma'am, it's always wonderful to interact and to share this platform with Sudhakar sir, Dipti ma'am, Bala sir. That's my honor, ma'am.
Thanks a lot. We'll give you trouble again in future then.
Sure. And I am looking forward for more interactive session. Insider trading is coming. So now I will participate as an audience and ask questions.
She there as an audience actually many a time, but she has come earlier also in our webinars, I remember categorically. Yes, thank you very much, Hema, for your support. We look forward
Yes,
at time in future for some time. I think With this,
Thank you.
we close the seminar with this, and we will meet yet another webinar in the next week in the second series of insider trading. That's the thing. Thanks a lot. Thank you very
Thank
much, Sakshi, for your nice presentation. You have made it very, very comprehensively, put up the things, everything very nicely. My compliment to you. Thank you.
Thank you, everyone. Thanks. See you next week. Bye.
Good night to everyone. Good night.
Good night. Officially, good night to everybody. We are in the good afternoon.
When you are back in India, now we will wait for the birthday treat.
Sure,
good night.
definitely. Thank you very much. Thank you.
Good
Bye.
night only for you.
Thank you, sir. Good night.